Welcome to Spoken Injustice, where we put the criminal justice system in the dock. We are currently examining majority verdicts. In today's video, we will examine whether it can be said that majority verdicts undermine the criminal standard of proof of being sure or beyond reasonable doubt. We will also look at a research which concluded that the inherent risk of miscarriage of justice is unacceptably heightened in jurisdictions that allow majority verdicts, where those jurisdictions also apply the beyond reasonable doubt threshold of guilt test. The research reveals that the risk result flows purely from the underlying mathematics. To understand the mathematics behind it, we will call upon our expert Professor Emeritus of Mathematical Statistics at Leiden University, Professor Rupert Gill. So do follow us until the end for this exciting session. We have given a background as to when and why majority verdicts were introduced in England and Wales. What was the position before their introduction in this video, which you can find linked in the description below. So let's start from our initial question. Do majority verdicts undermine the criminal standard of proof of being sure? Certainly some of those debating the majority verdicts clause during the Criminal Justice Bill 1967 discussions felt that way. Most of those dissenting felt that majority verdicts was a departure from the burden of proof of being sure, with some stating, as I have always understood it, we have endeavoured to prove guilt beyond reasonable doubt. What we are now saying is that there is only 2/12 of a doubt, and therefore it is all right for the person to be guilty. In other words, we are defining a reasonable doubt as 2/12. I am sure that this will weaken public confidence in the system. However, Mr. Grieve was of the view that the two principles must not be confused. He said it will still have to be made good beyond reasonable doubt. At least 10 members of the jury will still have to be sure in their consciences of the guilt or innocence of the accused before they can return a verdict accordingly. However, Hale pointed out, and this is something that we shall get back to at a later point, that the jury should not be seen as 12 people, but as a unified entity. This is what Hale said during the debate on the 26th of April 1967. I do not think that anyone will contravene what I say on the mode of proof. A jury is not 12 men on the top of a Clapham bus. A jury, if I may use a homely and almost vulgar metaphor from horticulture, is a collection of 12 odds and sods, some squares, some triangles, some little bits here and some there, as one relays the loan. We concur with the notion that the jury should be perceived as a cohesive entity rather than an assembly of 12 or any specified number of jurors. So are we allowing reasonable doubt to linger in cases in which a jury verdict is reached by majority? A recent research by Rupert Macey-Dare, published on the 18th of January 2024, suggests that the miscarriage of justice risk inherent in all criminal case retrials and majority verdicts at first instance, appeal and Supreme Court stages is much higher than previously thought or appreciated, and in fact often unacceptably high. This in turn must lead and have led to an excess number of miscarriage of justice convictions, incarcerations and penalties, even death penalty convictions in relevant states, that apply the beyond reasonable doubt threshold of guilt test, and which also allow explicit or implicit majority voting by jurors or appeal judges to determine the verdict. This very surprising, for lawyers at least, result flows purely from the underlying mathematics. The author states that specifically a majority as opposed to unanimous guilty verdict can produce a very high biased overestimate of the jury or judicial panel's average view of the probability of guilt of a defendant. This is because mathematically the implied probability of guilt in a unanimous guilty verdict does not carry over into a non-unanimous majority verdict. Put another way, the author said the mathematics of voting is different from and inconsistent with the mathematics of probability and optimal statistical estimation of guilt. Every explicit or implicit, for example through hung jury or retrial, majority case guilty verdict, where each juror or judge has applied a specific individual probability of guilty test, can nevertheless correspond to a situation where the average probability of guilt, as estimated by the pool of jurors or judges, is actually well below the average required probability of guilt threshold. This can in turn be used to estimate the actual miscarriage of justice risk and likely prevalence of miscarriages of justice for defendants who are convicted in such cases. Let's try to understand this by asking Professor Emeritus of Mathematical Statistics Rupert Gill to shed some light as to this finding.
Professor Gill, thank you so much for accepting our invitation to shed some light on this revealing research. What are essentially the findings, and do you agree with them?
Yes, the research is essentially very simple, and it's actually saying something which is very obvious, and that is that let me talk about the case of a jury of 12, and what happens if you would allow a 10-2 majority, for instance. As a special case, simple special case, there's some very simple arithmetic in it, but nothing difficult. And it's absolutely intuitively obvious. If you base the verdict on the 10 of the 12 jurors who have the strongest belief in guilt, the strength of the jury statement is not the same as it would have been if all 12 jurors had to agree together. Rupert Macey-Dare gives a little example of this, which relies on some numbers, and it relies on interpreting beyond reasonable doubt for a person. So if a single juror believes something is beyond reasonable doubt, how sure are they really? Well, he picks a number for that. He says they probably means they are at least 95% sure, right? And they could be more sure, of course, but it could be just 95%. Now, we know from psychological research that people actually do decide, decisively for one side or another side of an argument if they really admit that actually perhaps they would be wrong 5 times out of 100. It's an arbitrary number, but it seems to correspond to what people really think. Now, suppose you have a jury of 12, and suppose 10 of them have that 95% certainty, but suppose the other 2 are actually tending to innocence. Suppose they are like 5% certain of guilt, 95% certain of innocence. You leave those 2 out, and the average of all those of the 10 who are left is, of course, 95%. And this is what we call beyond reasonable doubt. If you would average all 12, the 2 of 5% and the 10 of 95%, you come out, I think, I calculate 10 times 95 plus 2 times 5, and I divide by 12. That's that average, and the answer is 80. So it's like 80%. Now, everybody realizes that if a jury is only 80% sure of guilt, there is reasonable doubt. 20% doubt is reasonable doubt. right? We deliberately have 12 jurors, and we deliberately insist on beyond reasonable doubt. In a civil case, judges or jurors decide on the balance of the probabilities, and they just decide what is more or less likely. And if you dilute a jury by removing two people who were not convinced by the evidence at all, it's not fair anymore. It can be very unfair. Of course, this was a special case where 10 of the jurors were only 95% certain of guilt. And if you would make them 99% and you'd leave out 2, then it would not have had so much impact. So the paper shows how bad it can be. It doesn't say that it always is this bad. Now, I think you can find out how bad it is by doing statistical research into rates of false convictions for similar serious crimes in the case of only majority verdicts and unanimous verdicts. I think you will probably find a clear difference in the actual resulting.
Indeed, and the paper also makes an example of the case of Andrew Malkinson, which is, of course, one of the recent cases where, in fact, the majority was a 10-2. So it is relevant that we have also cases that we can refer to where we can see that led to a wrongful conviction.
Yeah.
So it is right that Mr. Rupert Macey-Dare is looking at the jury as one body, because there seemed to have been some discussion in 1967 where a member of parliament debating the majority verdicts may have misdirected themselves in that they have looked at each single juror rather than looking at the jury at one body.
I think you have to do both. The idea of having a jury is that you are being judged by your peers, and the 12 jury members are basically a random sample of everybody. And what we want to find out is, I would say, is what would people in general conclude about innocence or guilt, given the evidence which has been heard in court. You're interested in the general opinion of the peers of the person who's being tried. And if you decide, well, I'm only going to rely on 10 of the 12 before I send somebody to jail or not, it's no longer representative of the peers of the person being tried. It directly violates the principle of being tried by a jury of your peers.
That is a very interesting point. Would you look more into these issues, do you think, in future?
Well, I don't think I'm going to, but I think people should do. There is clear room for good empirical research now, because we've got a sort of a theoretical picture which tells us that if majority votes are accepted, then it is more likely for miscarriages of justice to result. But now somebody must do some big survey. Will be very difficult to do, because who decides what is a miscarriage of justice, especially in view of how long it takes to correct them these days. I don't have a plan to do it myself. I can't immediately think of what I would suggest. It seems to me it's going to be very difficult. We have the Malkinson case. Give us a few more cases and you can start arguing to lawmakers about whether they should reconsider and change the law again.
Well, that has been enlightening. Thank you so much, Professor Gill, and we hope to have you on board on other research, hopefully, if you agree to accept other invitations from us. But for the time being, thank you so much for being with us.
Thank you very much for having me. Thank you very much.
Thank you. Bye-bye.
Yeah, bye-bye.
So to close with an example of a case which we have covered in several of our videos, the case of Mr. Malkinson, as we know, had his conviction for rape, for which he unjustly served 17 years in prison, quashed. The researcher states that in this case it can be seen that the original Crown Court conviction was based on a minimum allowed 10-2 juror majority. But if one applies average values for the estimated probability of guilt for all the jurors in this case, the average estimated probability of guilt is below the critical threshold for a relatively safe conviction. The original judge should have never accepted a 10-2 majority guilty verdict, and Malkinson and similar defendants should never be or have been convicted on such a tenuous and flawed verdict basis. The author of this research suggests that as this current situation of criminal cases verdicts delivered by majority voting must be highly inefficient both in terms of economics and equity, solutions should surely be sought as soon as possible. One simple approach, said the author, would be, for example, to restrict standard jury and appeal and Supreme Court sizes for criminal cases to no more than, say, 6 or 7, suitably selected from the relevant pool, but insist on unanimous verdicts and to ban retrials except in the most exceptional circumstances. I hope you found this video interesting, and if so, like it and also subscribe to this channel to help us with our mission to humanize wrongful convictions. Also, join our networking hub at spokeninjustice.net to take part in our roundtable discussions on issues that concern our criminal justice system. Join us next week when we will be discussing whether there is any link between majority verdicts and racial and/or class prejudice. We look forward to usher you as we sit and rise in this unique trial.